So you've just been served with a protective order in Maryland. What should you do? Well, I recommend that you immediately contact an attorney, and here's why. When you've been served with a protective order in Maryland, you're often given a week and sometimes less notice before your final protective order hearing. And this is significant because a lot can happen at that hearing. The court has the power to consider custody and visitation of your child for the next year. The court has the power to award possession of your home to the petitioner, the other party. The court has the power to even grant possession of your vehicle to the petitioner. Additionally, oftentimes, situations in which a protective order has been filed, there often can be a criminal case that comes from that situation. And at the time that the protective order has been filed, oftentimes my clients are unaware that there will be a criminal prosecution. And it's important that you speak to an attorney in order to preserve your rights with respect to that criminal case in the event that it does arise. A mistake that I often see is clients who, before speaking with an attorney, go into a protective order hearing unrepresented and speak or testify about an incident between themselves and a spouse or significant other that later comes back to haunt them in a criminal case. That's why it's important to make sure that you consult with an attorney and ideally are represented at the protective order hearing phase. Protective orders can be more complex than you think. That's why I always recommend speaking with an attorney as soon as you find yourself in that situation. If that happens to you, give us a call. My name is Rand Lucy. I'm a partner here at Jezik & Moes.